and welcome again. Well, my vacation lengthened to include a spell of 2 different health problems, which are now thankfully behind me, although they did significantly increase my time of absence. We finished by discussing the issue of voting in elections, particularly in Australia, with its peculiar concept enshrined in legislation that it's somehow a criminal offence to refuse to futilely attempt to grant a non-existent authority to third parties to exercise compulsion over oneself and others. The truth is that to engage in such an activity is itself a crime under natural law. How so? We start with the simple observation that every living entity on Earth, plant, animal or human, comes into existence imbued with 2 main imperatives, which are to maintain its existence until it has had an opportunity to reproduce itself. If we ignore these basic facts, then we have to devise another explanation for the laws of nature and biology. In the plant and animal spheres, these imperatives are acted out almost exclusively by instinctual processes. But in the human realm, where we experience self-consciousness and at least the illusion of free will, a topic for an entirely different discussion, we often confront the fact that individuals have differing, even opposing motivations, which, if acted upon without regulation, may lead to frequent disagreements, often involving violence or coercion. Humans also have an inbuilt mechanism to assist in solving such problems. It's called a conscience. The Latin root combines the prefix con, meaning with, and the word sciere, meaning to know. It implies an internal understanding of the consequences of one's thoughts and actions, particularly as they might apply to our relationships with other humans. I know that I've touched repeatedly on these principles, but they bear restating, if only because so many people have trouble really integrating them into their worldviews. Actions which support the 2 imperatives listed above can objectively be defined as right actions, or rights, because they are in accordance with the laws of nature, which are by definition immutable. Actions, especially when undertaken by sentient beings against other sentient beings, which prevent the lawful execution of either of the 2 imperatives, have therefore to be termed wrong actions, because they transgress the natural laws of existence. Some question the entire concept of rights, arguing that there exist only the various forms of human action devised by individuals, and that the consequences which follow are simply part of the natural order, in the way that while antelope may consume grass for sustenance, lions consume antelope for the same reason. The best answer to that is to point out that humans have not only individual intelligence, but the advantage of synergy, when these intelligences are combined cooperatively rather than in naked competition. In other words, groups of people working in concert, especially on large projects, are able to accomplish far more than each individual operating singly, and the sum of these combined efforts is far in excess of the total that would be achieved by the simple arithmetical sum of each individual's output. In the light of such almost incalculable advantages of cooperative endeavour over combative strife, it is clearly preferable to abide by the laws of nature as they have been laid down. Humans didn't invent the concept of synergy. It exists in nature and had to be discovered by people following the natural laws which govern the triggering of such a process. Now that it is known, to cast it aside in the pursuit of combative destructiveness is clearly an affront to natural law. So much so that it's axiomatic that the goals of rational people are not incompatible with each other. If we see 2 or more individuals at loggerheads, even motivated towards harming each other in pursuit of their goals, it's discernible that at least one of the parties, and possibly each, are acting irrationally in some measure. We can determine this by the degree to which they desire their individual actions to violate the laws of nature, which place each individual upon earth imbued with the self-same rights as every other one. Each is entitled by nature to seek to improve their own lot in life by virtue of their own efforts and those with whom they enjoy voluntary cooperation. Conversely, if in seeking their own improvement they deliberately, or even negligently or accidentally, infringe the rights of other individuals to do likewise, they infringe the natural law which applies to all and commit wrongs. Most people instinctively understand these principles. They know that it's wrong to treat people in ways that we wouldn't want to be treated, and they use this understanding to regulate their own behaviour. They seek to enjoy freedom, but recognise that it carries certain responsibilities. One of the most important of those is to be personally responsible for doing whatever it takes to uphold the common law or peace of the community, which of course includes being willing and personally capable of performing jury duty to a satisfactory, if not exemplary, standard of morality. It is completely unacceptable to be willing to shuck off this duty to some practitioner of the dark arts of political rhetoric or the shifty priestly class of those who have spent years training in the deceptive practices of the legal profession. Such widespread attitudes are just what has led us over many centuries to our current deplorable situation regarding justice and the application of law. Currently, what are called jury trials in the British Commonwealth are both a pathetic and a dangerous corruption of the original common law jury system established by Alfred the Great under the tutelage of his father and grandfather. There were judges involved in that system, but their role was advisory and they were strictly bound to abide by the verdicts and decisions of the jury. This law was so strict that Alfred had allegedly had no less than 44 judges hanged for giving false judgments, that is, those which overturned the lawful verdicts of juries and resulted in legal homicides. Such actions were rightly classified as treason because they sought to undermine the efficacy of the monarch's oath of office, which is to protect the natural-born rights of every crown subject. Under existing constitutional law and also various statutes, the current bastardised jury trial system, where the judges commit numerous serious offences against natural or common law, as established under Magna Carta 1215, is also treasonous. What are some of these offences? We could begin with the fact that under Magna Carta Article 39, the Crown gives a sworn and sealed promise to abstain from moving in any way against any subject without there first being a guilty verdict given by a jury of the accused's peers. We could follow with the judge being in the employ of one of the parties to the case, the state, which obviously renders them incapable of giving an impartial judgment, or at the very least establishes a prima facie case of conflict of interest. Under Magna Carta, then, any trial conducted without a jury being present is null ab initio, invalid from the beginning. Ploughing yet further into the field of legal excrement which has befouled virtually every aspect of the best constitution ever devised, we find the heinous deception of judges deliberately hiding from jurors the fact that they have full and total independence to form their judgments bound only by the diligent application of their consciences, irrespective of any enacted legislation or direction from said judges. This, despite there being a plaque stating the very same principle affixed to the wall of the Old Bailey, citing the Bushell case involving William Penn and others as far back as 1670. The sheer gall of this, what can only be objectively described as a monstrous lie, beggars description. Yet the average Crown subject, despite all the evidence, remains abjectly ignorant either of the law or their right and obligation to rail against such deliberate perfidy until it be removed. This very principle was recently the subject of a case sought by the Solicitor General against one Trudy Warner for the crime of holding a placard outside the court informing jurors of this very right and duty, namely to use their independence. Although Ms. Warner didn't approach or speak to any of the jurors, the Solicitor General saw fit to take her to trial for allegedly interfering in the judicial process, alleging contempt of court. However, in a strong blow for the defence of this right of jurors and of free speech, the High Court, under a ruling issued by Justice Saini, struck down the application to prosecute Warner, citing, quote, a significant mischaracterising of the evidence, end quote. However, despite quoting Lord Bingham's reiteration of Sir Patrick Devlin's statement of the principle that jurors had the right to refuse to bow to legislation which their consciences told them was unjust, Justice Saini nonetheless had a bit of an each-way bet, obfuscating the issue by not giving unqualified support to the principle, presumably lest too many of the common people got the idea that here was probably, as Devlin had said, quote, the only real check upon the unfettered power of the executive of which he was aware, end quote. These are the most egregious of the offences against justice and our natural common law rights that operate today. Time and space limit the amount of attention that can be given in a video such as this. However, the Warner case raises a vital point on this whole issue, and one for which the whole society is indebted to Trudy Warner. The question is often trotted out as a rather pathetic excuse by hordes of people. Well, I'm only one person, what can I do to change the world? The key point for the average person to grasp is that corporations, unless one has signed a specific contract, have zero lawful authority to compel a private individual to deal with them, and that our entire government system, from the executive to the courts and the police forces, has been treasonously and unlawfully converted, without consent of the population, to a connected series of corporations, which likewise have no lawful authority to compel anyone. Once enough people know this, changes can be established by the momentum of public opinion. Sadly, most people are so distracted by the manipulations of these corporate bodies that they're not going to do anything until there is literally no food available for them to feed their families. Before then, an economic crisis, which is now in the process of gestating, will loom up, and the solution offered will most likely be a central bank digital currency, complete with enslavement by digital ID. I fear that almost everyone will fall for that, and those who don't will be persecuted, as with the COVID-19 mandates. But in a world where everyone submits to such slavery, even one person refusing to do so objectively creates a different world. So I don't worry what everyone else is doing. That is their responsibility. I am determined to live according to the truth, even if I'm eventually murdered for it. When someone says to me, I'm only one person, what can I do to change the world? That is my answer. We can choose to become like Randall McMurphy in One Flew Over the Cuckoo's Nest, who we recall attempted to uproot the water fountain in the asylum, but was personally unable to do so. When asked why he attempted such a seemingly impossible task, he replied, well, at least I tried, didn't I? I did that much. Later, the feat was accomplished by the Indian chief who did have the strength. We are engaged in a task which may well require more than one human lifetime to accomplish. That is the choice confronting each individual. Our individual examples, like that of Trudy Ann Warner, may inspire others to later achieve what we may yet only attempt. Next time, we will revisit the events of 17th century England for further insights into how our current situation was manipulated into existence. There will be some interesting highlights. Thank you for watching.